and to be hearing from our guests today, which are...
Sorry, Marcus, I've completely forgotten one more thing. I'm just about to switch on the recording, just in case anyone objects. My apologies. Okay.
No worries at all.
Good. Okay, it is recording, I think. Yeah, good. Sorry.
We received the message on the recording.
Okay, cool. Thank you.
That is perfect. Thanks, Patricia. So today we have the great opportunity of hearing from our three guests, and we have with us Dr. Reut Paz. Is that how I correct? Is that how I pronounce it?
It's Reut.
Reut Paz.
I'm used to answering any possible format of this.
No, I'm sorry about that.
Yeah.
Reut is an Israeli scholar. She specializes in international law, European law, international relations, and legal history. She studied law and political science at the University of Helsinki and got her PhD from Bar Ilan University in Israel. She has won several scholarships, and she conducted research for 2 years as a postdoctoral fellow at the Alexander von Humboldt Foundation in Berlin. She taught international law at the College of Management in Israel and international legal history at Humboldt University as well. She has been to Freie University and the University of Wisconsin Law in the US. And we also have with us here Dr. Ioana Cismas, who is a reader in York Law School, where she teaches, conducts research, and provides legal and policy advice in public international law, human rights law, international humanitarian law, law and religion, and transitional justice. Ioana, is that correct as well? I just double check. Ioana joined the Center for Applied Human Rights at York in October 2017, a place I really admire the work you guys do with international human rights defenders. She is the joint program leader of the LLM in International Human Rights Law and Practice, and her research is applied, interdisciplinary, collaborative, geared towards impact generation. She also has a significant number of grants in her CV here, and she also has a few important connections with non-governmental organizations and charities. And we will also hear from Professor Russell Sandberg. Russell is a professor of law in Cardiff. His research interrogates the interaction between law and the humanities, and he's the author of a significant number of books, such as Law and Religion, Religion, Law and Society, from Cambridge University Press, Religion and Marriage Law, The Need for Reform, from Bristol University Press, Subversive Legal History, a manifesto for the future of legal education, and Religion in Schools, Learning Lessons from Wales, which explores recent reforms to teaching religion in their historical contexts. So because of the technical confusion here, we didn't have the time to combine before the program started, who was gonna go first. But since this is International Women's Day, I will take the lead here and decide that the ladies will go first. Professor Stefan will speak later. And I think if we organize for 10 minutes for each of you, then we can have a brief, a joint discussion in the end, and this should fit into an hour or so. Is that okay? So, Ioana, would you start, and then we follow from you?
Sure, happy to do that today and every day. Thank you very much for the kind words about the Center for Applied Human Rights. I'm actually the new co-director of the center, and it means a lot to us to, especially today, but really every day, to know that our work with protecting human rights defenders at risk, and especially women human rights defenders at risk, is known. So thank you for that, Marcus. What I'll do today, I'll try to keep it really short and speak a bit about a project that I have just concluded. And if you allow me, I'm going to share my screen just because the images look better than I do today. So just give me 1 second to share my screen. Can you see my screen? Yeah, okay, that's great. So I'm going to provide some findings from project that I have led. It's a project funded by the Economic and Social Research Council, and it looks at the influence of religious leaders on parties to armed conflict, and whether they contribute to generating respect for humanitarian norms, and how. And by humanitarian norms, the way we define them in the project is norms under international humanitarian law and human rights law applicable in times of armed conflict, both non-international and international armed conflicts. So this project started in January 2020, and it ended at the end of February 2023, so a few days ago. We worked with Geneva Co, a humanitarian organization that engages with non-state armed groups around the world. And we worked co-productively, meaning our researchers were Geneva Co staff. They were hired to work on the project and for Geneva Co. And we developed much of the research in Mali, in Libya, Syria, and Yemen together with them. And then in Myanmar and Colombia, we didn't work with Geneva Co, but we worked with other supporters and partners. So this project is very close to the topic international law and religion, but it also intentionally avoids talking about religion and instead focuses on religious leaders, which I sometimes refer to religious actors. This is in reference to my book, Religious Actors and International Law, that was published with OUP in 2014. And the reason why we take in this project, and more generally in my work over the last decade, why I take actor-focused approach as opposed to a religion-focused approach is to escape what tends to be portrayed as the inevitable conflict between law and religion, which I think exists if we just look at the books and the texts. But if we look at actors that interpret religion, we understand that there is a dynamism across time and space, and we should rather focus on the accountability and the legitimacy of actors interpreting religion as opposed to religion as such. Of course, the two aspects can't be divorced. So coming back to the project on generating respect for humanitarian norms and the influence of religious leaders, the problem arises out of the experiences of humanitarian organizations on the ground. It's described by them in a sense, direct engagement with parties to an armed conflict works, but almost to a certain extent. Therefore, in recent years, we started looking at the influencers of parties to an armed conflict, and these are, among others, religious leaders. We are trying to build a reflexive community of humanitarian practice, so to ask ourselves, do we even have the ability or the right to exclude certain actors, such as religious leaders, from engaging in humanitarian practice? They do on the ground, so can we actually make decisions as to whether they should or not? And we're also looking at literature from other quarters, such as development, transitional justice, such as peace building and peacemaking, to draw on that literature and its engagement, or their engagement with religious leaders, which is much more advanced than IHL or international human rights, or in armed conflict, focusing on norms compliance with religious leaders. Again, not with religion, with religious leaders specifically. So We developed this project over 3 years, as I said. We had 6 case study contexts. We drew on interdisciplinary literature review to develop the conceptual framework. We did it iteratively, meaning we used the thematic analysis from over 250 semi-structured interviews and digital stories with religious leaders in the 6 case study countries, with both states, but especially non-state armed groups, former and current members of armed groups, with community leaders, with humanitarian scholars and practitioners, to further refine the conceptual framework. And we also held a series of consultations on the preliminary findings. There are a number of outputs of this project. There are some academic outputs, a forthcoming issue of the a special issue of the Journal of Human Rights Practice dedicated to the topic of the project. There are some really interesting digital stories where religious leaders and humanitarians talk about the engagements that they had. And the specific one on Madame Cissé, she's actually talking about how she's not being engaged with, she's a religious leader in Mali, how she's not being engaged with by humanitarian organizations, because in her experience, in particular, international humanitarian organizations tend to associate religious leaders in Mali only with imams, so therefore they do not see, literally, they do not see female religious leaders. The last bit that I would like to talk about is the operational output of this, so the operational document of this project, which is titled Considerations and Guidance for the Humanitarian Engagement with Religious Leaders, a document addressed to humanitarian organizations in particular and to donors who fund such engagements. And what we focused in this document is on how we should define religious leaders, how they influence armed actors, both states and non-states, why to engage with them, and how to engage with them. I'm going to really speed through because I think I have 2 minutes, if I'm not mistaken, Marcus?
Yes, sort of 2 minutes.
2 minutes, okay, that's great. So what we found, and again, the definition that you see there has been developed iteratively, drawing on literature, my own and others. And what we found in practice is that it's very important that for humanitarian organizations to look at religious leaders not through a Western lens, not through a patriarchal lens, and therefore, it's important that informal affiliation with religion is taken as a central part of the definition, and collective forms of religious leaderships, especially informal collective forms of religious leaderships, are taken into account. And one specific finding of importance to humanitarian organizations is that religious leaders can be also internal part of armed groups and state armed actors. For instance, we have religious leaders who lead the political wings of non-state armed groups, the military wings, but we also have chaplains in both state and non-state armed groups, and those are internal, although they differ. But there is an implication for their status under international humanitarian law. Okay. Very briefly, the question that we asked whether religious leaders have an influence on armed actors was very clearly answered with yes, and this influence can be direct or indirect. It can be lasting and profound, which is very important because it's linked to processes of norm internalization. That's the strongest form of socialization, or it can be superficial and temporary. And it also can be positive, leading to or increasing norm compliance, and it can be negative. So you can have combinations of each of this. one important aspect that we found is that religion itself, so a shared religion with an armed group, for example, does not explain necessarily the influence of that religious leaders on that group. So we should not essentialize religion. Very often it is just one, or it doesn't even have to be one of the factors. So again, essentializing religion is the wrong path in our view. The type of interactions of religious leaders with IHL and human rights law, it's by far not a black and white. It's by far not just support or violation. It is religious leaders being themselves humanitarians, directly implementing the humanitarian norms, examples that we found in Myanmar, where no other humanitarians for quite a bit after the coup d'etat were able to get in, but religious leaders were. And then all sorts of other processes of vernacularization, localization, strategic avoidance, silence, hybridization, and rejection and violation of norms. So I think that's it. My time is up. So I'm going to thank you for that. You find the considerations and guidance on our website, and the website is just listed there. Thank you. Looking forward to the discussion.
Thank you so much, Ioana, for your presentation. Can we listen now from Reut? Did I get it correct? Oh, I tried.
No, it's all good. It means friendship in Hebrew, for what it's worth. Yeah, thank you so much for having me, and thank you for the previous talk is very tuned with what I want to say, which is not very clear because I wasn't very clear about what it is that we're going to be discussing and how the format is going to work. But let me start with a similar apology to Marcus's. Yeah, it's the International Women's Day, which means kids are at home all day. And yeah, so, and the internet doesn't work. So there are lots of problems happening simultaneously here, but you can't stop life from entering law or religion for that matter. So yeah, I also would like to, I'm also haunted by religion, or rather, like I'm very religious about taking religion seriously when it comes to international law and its actors. So it's very similar to Ioana's talk just now. I've always investigated how is it that our agency, our personal agency, and our personal religious background impacts the way we think of law. Because both religion and law deal with moral issues, right? And I would like in this format, because it's the International Women's Day today, to also just mention Helen Sylvine Rouy, who was one of the protagonists that I've actually worked on. And she was the first woman to have become a professor of law in the United States, in Puerto Rico, in the early 60s. She was born today in 1906 in Krakow, and she was Hans Kelsen's only female protagonist student, and he's helped her also get that professorship. So I think that's and I think that there's much to unpack with how she specifically, but also others, have brought a Jewish perspective into international law. And given international law, I mean, its major bias is actually Christianity, which I'll talk about in a few minutes in more detail. I think that's also important to sort of to keep in mind, or to keep an openness to different types of religions, because when we think of international law, the Christian bias is just so overwhelming, right? But speaking of protagonists or religious leaders and how they've impact the way we also think through legal structures, I just heard an interesting talk last week in Cambridge by a woman who was writing about why patriarchy is so hard to avoid. And she just gave an example that I thought was fascinating, and I had no idea. But apparently, so how transgender people are being considered in two different religious communities. And she gave the example of Iran versus the way the Pope deals with transgender people. And basically, Catholicism just sees transgender people as people who have mental issues that need to, so their spirit is harmed, and that's how they're perceived. Whereas in Iran, interestingly enough, they see it as a physical issue, and that is why transgendered surgeries are being financed by the state and being endorsed, and so transgender people are receiving medical care because they see it as so it's interesting how two religious communities actually perceive our biology completely differently because of their religious background. So the body mind, the duality between the body and mind. So whenever I think of religion and law, I always think of Durkheim, who said that the very idea of society is the soul of religion. And I think that's really a starting point. So if we think of the superstructure that we're dealing with, or at least I deal with, is religion, secularism, and then international law. And international law is obviously just one facade of secularization, right? So a secularization move that happened with international law in the 19th century. So given, as I mentioned, religion and law resorted to in questions of morality or consciousness, similarly, or consciousness, which is an important word for international lawyers, it's really important to see these superstructures and how they interact with each other. And my starting point is always that international law is not as unreligious as we think it is. So, there's a lot of religious images happening. And importantly, the exchange between, mainly Christianity, but religion in general, and secularism is constant, but it happens through a very profane image of what Christianity is. So it's not Christianity, it's not Catholicism. It's just a very profane understanding of what these concepts can be. And the other aspect that is important to keep in mind when we think of these issues is that the reality of international law, it's knowledge. So as a body of knowledge or a discipline, is socially constructed and socially and historically constructed, and ideas have homes, right? So if we think of international law as an idea or as knowledge, as a bulk of knowledge, we need to think of it, where does it come from and what did it come with, right? So modern international law was born as a product of a liberal empires turning to formal annexation, so of the New World. But the ideology obviously goes back, so it starts in the formal constitution of it, and here I follow Martti Koskiniemi. A formal constitution of it is, done by 11 men, mainly Protestant, but also a couple of Catholics, deciding that they are, the international consciousness of the civilized world, and they inaugurate the first institute, the Institut International, and they. So if you would ask in the end of the 19th century, where is international law? Basically, the answer would be in the consciousness of these 11 men. These men were Eurocentric, anti-Semitic, so, in very general terms, misogynists, anti-Semitic, so in our woke culture, I don't know how much, gravitas they would get, but yet, this is how 19th century kind of pushes through international law. And it's interesting that so the project of the international legal project, or the modern international legal project, starts when Europeans have stopped, or at least the wars in Europe about religion kind of decline. And then there is a push for an international legal project. That is a pseudo-secular project, right? So it's not at all religious anymore. And so it starts with the 19th century, but the ideology goes deeper back into the school of Salamanca, and the way they criticize the Spanish Empire. And again, Martti Koskiniemi has written enough about it, so I don't want to talk too much, but I just want to mention the most important thing with international law, but maybe all law, is that the private-public distinction, right? So, you know, we have the public that's regulating issues of territory, jurisdiction, wars, etc., and then the private regulates property, commercial, and contract law, etc. So this distinction happens together with the Salamancans, but you know, it moves throughout this into modernity. And what's common to all, you know, to this distinction itself that is very, very difficult for us to break away from, is that it's very Christian, it's very Eurocentric, and the character of international law just remains a tool of subjugation in the name of liberation of the other, right? So whatever that other may be. And this is basically the Achilles heel, if you like, of the discipline. So the Christian impetus that is carried with its missionary logic is constantly there. And I think that if we don't always go back to that point, we cannot really understand the problems of religion and law, right? So how do these superstructures work together? Another thing that I would like to just throw into the air is that often when I say Europe or when I say Christianity, it seems as if it's, you know, clear-cut thing, right? Like Europe is, you know, obviously that's not at all the issue. It's never been the issue. It probably will never be the issue. So, you know, we don't really know what Europe is, and we don't really know what Christianity is. It's fragmented, and mostly the need to camouflage the fragmentation has a dire price on many others that are being hidden or kind of shoved away and excluded. And in most of my research is dealing with these issues through individuals, so specific individuals and their religious heritage. So it's images. Again, most of these, mostly men, but also women, have kind of shied away from admitting their religiosity. And when, you know, so my book is about Jews and international law, or Jewish scholars and international law. And it's, you know, and I do think that the Jews, because of their homes and, you know, the history of their, the histories and the societies that they came from, they brought a different type of understanding of what the particular is and what the universal is, very nuanced and very special, but it's an important addition, and something that they participated in this conversation in a completely different way because of their situation. But, you know, without further ado, I'll just leave it at that. I hope I kind of, you know, threw some ideas into this discussion, and I look forward to, you know, the debate at the end.
Thank you very much, Reut. Let me, before I, you know, give the floor to Professor Stefan, let me just correct here, because he didn't interrupt me, but I read the wrong biography. So I just want to read the correct one. He was very kind not to correct me at the time. So Stefan Oeter is Professor of German and Comparative Public Law and Public International Law at the Law Faculty of the University of Hamburg and Managing Director of the Institute of International Affairs. He's a chairman of the Independent Committee of Experts of the European Charter for Regional or Minority Languages, the Council of Europe.
I was some 10 years ago. That's old stuff.
A member of the Scientific Advisory Board of the Federal Ministry of Transport and member of the Permanent Court of Arbitration at The Hague. His main fields of interest and research are comparative federalism, minority protection, humanitarian law, European and international economic law, as well as theory of international law and international relations. So I give you the floor with my apologies.
You must not apologize. Well, before I go in detail, some general remarks, because I assume I was invited because I co-edited with two colleagues, Evelyne Lagrange from Paris 1 and Robert Oppan from Regensburg, a volume published by BUL some 5 years ago on religion and international law. And it was in essence, it were the proceedings of a joint workshop of the German Society of International Law and the Société Française pour le Droit International. And we tried to map a bit the field, and you realize, like Reut said already, there's a lot of religion in the history of international law. Another example, you can say, what the political scientists call the Westphalian order is in essence a compromise construct to get a way out of a fiercely fought religious conflict, and there's a lot of compromise between religious issues in the original Westphalian peace treaty, and you find comparable things throughout European history, even until it continues even into the 20th century. But I don't want to talk on history. I think if you map, and that was also our our impression, there are some classical international law issues, the status of the Holy See, and the treaties. This concludes with states on issues of the Catholic Church, or you have states where religious hierarchy and state apparatus are more or less fused, like Iran, and where the external dimension of religion easily gets a question of public international law, because it's external action of the state. But I think in most cases you end up in human rights, and the book largely was also on human rights issue of religion and international law, and I think that's unavoidable, because in most states the situation of churches, religious organizations, they are counted as part of civil society, and as part of civil society, the relationship between state and them becomes an issue of human rights. We are back at what Reut also talked about, the public-private distinction, which is so so old in European legal thinking, and it leads to this phenomenon that most issues of the position of religion in societies are phrased in human rights categories and terminology, and debated in human rights discourses. This kind of civil society character means that there's ample room for classical liberties against the state. Although I would say there are a lot of more complex cases because we have more and more pluralizing societies or pluralist societies. We have more and more cases where values, interests, epistemics of different religious or secular communities collide with each other, and the state is called upon to mediate, to find solutions, to limit freedom of religion of one group in order to in favor of freedom of other groups, and this becomes particularly complex in situations where you find what I would call strong religion in the sense of communities where religious ideas, religious concepts still dominate very much the life patterns of members, which is not true for mainstream churches in Western Europe anymore. And that's one of the reasons why in Western Europe you find all these cases mostly at the interface between more radical fundamentalist versions of Islam on the one hand and secular societies. This is an issue which has bothered me over the last years, and I've written several papers on this issue together with a research assistant also dealing with that. And I will want to talk a bit about that issue. The paradigmatic case for that, which I think, and that's my last remark then, I think lays open to a certain degree an internal clash of guiding ideas of liberal constitutionalism. The paradigmatic case is the French burqa ban, which has led to contradicting decisions of the European Court on Human Rights and the Human Rights Committee of the United Nations on the same issue, on the French legislation of 2010. And just briefly on the basic arguments of the two decisions, the European Court on Human Rights of the SAS versus France case of 2014, he found the burqa ban compatible with the European Convention on Human Rights, and he saw clearly an interference with the religious freedom and also a potential problem of equality, but he found it justified, the interference of the French state, although it's a quite strong interference. If you take a woman which is really believing in this radical strand of Islam and who is in a way banned from public, if she remains loyal to her belief, the court it kind of explicitly leaves a very large margin of appreciation for the member states, which he calls better placed to assess local needs and circumstances, and this in particular being true for relationship between state and religion. He accepts the French argument. He doesn't accept public safety because that's clearly excessive in justifying the wholesale ban in all public places. But he accepts the French argument of vivre ensemble, in English, minimum requirements of life in society. And if you go to the equality, he glosses over. It's very superficial. He refers to his examination of Article 9 of freedom of religion. He doesn't take seriously the issue. This is one of the, as a human rightist, I would say, this is really one of the main arguments if you are used to work with the concept of discrimination in terms of intersectionality. It's the argumentation is nearly scandalous in its superficiality. But I only want to mention the case because it's expression of a certain trend in liberal constitutionalism, and just the contrary position was taken by the Human Rights Committee in the two cases, Yaker and Hebaj. The Human Rights Committee thought the burqa ban legislation to be disproportionate curtailment of the freedom of religion under Article 18 of the ICCPR, and he didn't see any justification. He didn't accept the kind of the objectives raised by France, neither public safety nor the objective of living together, of vivre ensemble, and it also argued that there is a kind of, even if one would accept the objective of vivre ensemble, the legislation is clearly disproportionate. And the Human Rights Committee also took seriously the equality issues, even more in the concurrent opinions of some of the more progressive members, which would take up these issues, at least implicitly, of intersectionality and point to the fact that it's a very harsh treatment of women which kind of live in that belief system, and declared also a violation of Article 26 of the ICCPR. So you have two completely different argumentations in the language of human rights. And that's what I said. I think here comes to the surface a basic clash of fundamental principles of liberal constitutionalism. You have more in detail kind of a conflict between ideas of multiculturalism and feminism, but there's also an internal feminist struggle on the issue, how paternalistic progressive idea on feminism should be, and how much it should respect the kind of the preferences of the individual women. But I think it's even going beyond, and you come to what is really behind, I would say, well, conceptualizations of different basic values of a functioning pluralist modern society. You can conceptualize that in a more communitarian way, in saying the society needs some homogeneity, and this homogeneity must be expressed in a kind of not sacred but protected common pattern of life. That's the French idea of vivre ensemble. And if you accept that, you have a kind of communitarian idea where individual freedoms, also freedom of religion, has to go to the background, and the state has a right to impose that majoritarian kind of idea of common of the common good, and the other strand is a kind of radical individualism, saying no, what counts are the individual ideas, and since individuals were not really violated by women wearing the burqa. There is no human right, no individual right of not being shocked by expressions of different cultural attitudes. So in that sense, from a mere individualism, there's no reason of curtailing that freedom, and you end up in a completely different idea of that. And I think it's not. I kind of worked that out a bit more in detail in one of the two articles which was published 2 years ago in the Israel Yearbook on Human Rights. So it's not astonishing that the one idea is very much linked to France, which has from this old kind of revolutionary move this idea of a common progress, which in a way is paternalistically in a communitarian mode, must be brought forward in society. And the other position you can find very much in the jurisprudence of our constitutional court, of the German constitutional court, which is very much kind of focused on individual rights, on individualism, which has also to do with strong historical legacies, in particular the kind of nearly sacred role of our fundamental rights catalogue and the basic law after 1945, after the Nazi horrors. So in that sense, I think it brings to the limelight an interesting clash of different ideas. And I cannot say what is the right way of dealing with it, because I think that depends really on the situation. I'm not so sure that we will, let's say that Germany will come along without any problems with its radical individualism. I have some doubts about the radicality of the French communitarianism, but I think it really depends on the concrete situation, how to balance the different approaches. And I wanted only to shed light on these kind of what I call the internal contradictions of liberal constitutionalism. Yeah, thanks.
Thank you so much, Professor Stefan. And I think we now have some time, at least 10, perhaps 15 minutes for discussion. And I would like to invite our attendees to raise their hand. Or Patricia, should we ask for questions in the chat for the sake of time? What do you think?
Yeah, either way, if you want to put questions in the chat, we can certainly read them out. Yeah, absolutely, it's no problem.
I will, and I will use the power conferred to me of having a microphone open to ask a first question then, which is, do you think, liberal constitutionalism, taking from Professor Stefan, is under attack. So it's not an easy, it's not easy to attack it more, it's not strategically good to attack it more than it already has been attacked. But I wonder if you guys have thought about, is secularism and this difference of public and private a Western Christian thing or Western Jewish, Christian Jewish thing? And is it possible to see secularization outside this Western framework and the liberal constitutional conceptions we have in what we call Western countries? And I'm asking this question from, my experience in Brazil, where we are supposed to, be in a country with no religious conflicts in the last century, but we recently found out that the state has, repeatedly depredated African Brazilian religions and temples and native Brazilians. And I was there at a ceremony where the state, the State Secretary of Human Rights in Rio de Janeiro gave back to native Brazilians and African Brazilians religious leaders artifacts that had been confiscated in the last 200 years. And the funny thing was that some of the religious leaders said, we cannot take it. we need to consult the spirits first. So the state was, had to wait to be able to give back the artifact. So is it possible to have secularization and public-private distinction outside Western countries?
First, one cautioning remark. I didn't want to attack liberal constitutionalism. I think what I described are two different varieties of liberal constitutionalism, which each have its kind of historical record and its plausible concept, but which have its follow-up problems if you operate on this basis in detail. Your question is interesting. I would say intuitively, more than intuitively, that probably our current ideas of secularism, they are a product of modern European societies. I think if you go back in history and over different parts of the world, there was always a strong role of religion. There might have been societies, if you go to India, there always was a plurality of religions which you had to organize, but there was always a strong role of religion. This idea, and this is even more visible in the French idea of laïcité than in the German version. This idea that religion is something purely private, which doesn't have any role in the public domain. I think that's really a product of, you can say it started with Enlightenment and of the last 250 years of anti-clericalism and all these struggles which happened in 18th and 19th century, and which leave still its strong marks in today's societies.
And in that sense, I would be skeptical. That every time a German says that it's in France, it's Savigny, right? I mean, Savigny has established the distinction between the private and the public to an unimaginable extent and internationalized it. So, and Savigny's religious background, let's not even get there, right? I mean, it's like such a horrid mess. But Marcus, I just wanted to say that I don't buy the argument of the Judeo-Christianity. There is no such thing. It's just Christianity through and through. And no, unfortunately, I do not think that we can bypass that. So I don't think that, in the way that with colonialism, it's just, can we get over the post-colonial moment that we experience? I don't think so, unless you maybe have a different experience. I'm afraid it's very difficult to think of international. I mean, that's the bias, right? That's the problem. And even the idea of, human rights is a Christian idea. The idea that there is a distinction between private and public is a Christian idea. In Judaism and in Islam, you don't even have that, right? There is no division. So yeah, that's my.
Can I jump in here? I actually disagree with the portrayal of Western Europe as secularist, and certainly North America as secularist. I think this is one of the myths that we're buying into, which simply does not correspond to reality. France itself, despite its wonderful laïcité, I don't think it's even half as secularist as we like to present it. And I'll give you an example from Switzerland, if you want, where the state is still today collecting church tax for a certain religion in certain cantons. You have several countries in Europe, certainly in Eastern Europe, a part of the European Union, where religion teachers are priests and are paid by the state. So there is no clear division. Yes, it's constitutionally enshrined. And don't start me with the US. I just came back from Georgetown. So I think it's just a myth, and we really shouldn't propagate it. We should look into critically into this idea that Western Europe and the global North is secular. It's not, I think. It may be different, but and sometimes more subtle, but more penetrating, actually. It may restrict what religious leaders can do than in other parts where they're more independent, I would suggest. When your salary is paid by the state controls you. Anyway, leaving that aside, I think maybe this is the feminist movement in international law. What they have achieved in the 30 or so years is really this breakdown of the private and public division. Increasingly, it's not perfect by no means, nor will it ever be perfect. I think we're living in a pluralist international law, and this has been done precisely by scholars in the global south and feminists and TWAIL and other type of fringe scholars. And when we're talking about this private-public division as if it would still be intact as it was for a long time, and here I agree with you, I think we're doing a disservice to those who have really worked hard to chip away at that, including people that did acknowledge their religions and others that acknowledge that they don't have a religion. So yeah, I just wanted to bring in a tiny bit of a critical note on presenting Western Europe as a secularist.
Thank you so much. I think we have a second question from...
Sorry, just one remark on that. I treat it as more as a guiding idea than a description of reality, because I think you are completely right. And Germany, for example, is only a halfway secularist society. There are still a lot of traces of the old state church system, like you described it from Switzerland. So that there is no common practice of secularism. It's a guiding idea, which is in the concepts of constitutionalism.
But before Patricia gets to ask her question, I just wanted to say that, yeah, secularism was a religious movement to begin with, right? So let's avoid thinking of secularism as such as anything that, you know, is not involving religion. So it is a religious movement, and it's taken different shapes and forms. And in Germany, by the way, you still, you know, pay church tax, right? Jews pay church tax to the, you know, to the state. I can't even get out of the Jewish community right now. Yeah, like, I mean, because I have to go to the state to get, I mean, it's madness. So there's no secularism that's not religious to begin with. Just a comment, but Patricia, please, sorry.
Okay, hi, thank you. Really amazing presentation. Thank you so much. I've just got a couple of questions. The first one is to Ioana, I hope I'm pronouncing it properly, and it concerns armed groups. I'm just wondering whether you in your research, you went after, you know, proper officially armed groups so I'm talking about sort of that kind of distinction where, you know, if you're properly recognized, then you're under the jurisdiction of the Geneva Conventions, as opposed to other maybe more dubious armed groups that may or may not respect international humanitarian law, and therefore may be more difficult to actually include in your research. So I'm quite interested about that. And the reason I'm interested actually is because it came up as part of our teaching yesterday. I teach international humanitarian law, and it came up as a question from one of my students regarding the need for the criteria that armed groups need to have in order to be recognized as an armed group under international humanitarian law. So I was wondering whether that's the one that you use in your research. And generally to the three speakers, clearly international law has been criticized for long enough about being Western European and clearly very much Christian. So what, in your opinion, if anything, can be done to sort of insert or inject international law with some diversity? I mean, obviously we know that organizations like TWAIL, people like TWAIL are trying to address this imbalance. But can anything else be done to actually correct the imbalance that has been created centuries ago and is still continuing in our, not just in practice, but also in our academic teaching to some extent? And I just wonder whether you had any thoughts on that. Thank you.
Just before you guys start, we have another question in the Q&A, and then after you do Patricia's question, we move to that one, and then I'm going to end for questions. Okay.
I just don't have much to say, but I also, Ioana, you mentioned the TWEL as a fringe. So I just wanted to say, don't know how fringe it is anymore, right? So the good news is that, you know, if I don't know, TWEL was something that Anthony Angie or you know, the critical legal studies in Harvard, whatever, if they've kind of started it, it's not really fringe anymore. Which, you know, gives us an identity crisis to deal with, right? So, but I don't really know what the answer would be. So I think that to look at the problem is the first step. I don't really know how to overcome it, except for really looking for different examples where it actually worked better. So I've worked on status quo of Jerusalem, for instance, and the only thing that works in Jerusalem is the status quo that the Ottomans, a Muslim regime has kind of put in place and given the holy place, the Christian holy places, into the hands of the Muslims, and it works until today beautifully. Whereas Christian international law, the United Nations and what have you, have tried to deal with Jerusalem for a pretty long time, have not managed to do half the bit that the Ottomans have. So maybe, telling these type of stories of, different histories, or her stories, whatever, adds a little bit of nuance and adds a little bit of layers that could be, unpacked further in the future. Because really, we know that the history that we know is, the victorious history, and it doesn't really mean that it's even victorious, right? So anyway, my kids are making so much noise, I feel really bad, so I'll just put the silent.
But my remark would go very much in the same direction. I would say, if we want to reflect critically the European legacy, we should at least be aware that probably the European guiding idea of secularism is not the only way of organizing a peaceful coexistence of religious communities. And I think your example from the Ottomans and the Ottoman millet system is a good example of that. And I'm quite sure if we go to the Indian history, we will find a lot of examples as well. And these are conceptualized in completely different terms than modern European secularism. So in that sense, I think, which is a bit an answer to Marco also, I'm skeptical whether we can universalize European secularism, but I also think it would not be a good idea to universalize it, because it would not, in a lot of societies of the world, probably it would not help. It would create more damage than it would help. And that way, we should be more critical with our guiding ideas, which come from our own history.
On the question of the Universal Declaration, there are quite some interesting studies and books written on how it was prepared, how the Universal Declaration was prepared, who was involved in drafting, but also on a survey, if I'm not mistaken, that has really looked into bringing in views that are not just those of the drafters. Among the drafters, there were not only Westerners, but that, but be that as it may, there was actually a wide survey, and it was really interesting. And I would suggest also maybe looking into the interesting debate between the American Anthropological Association those times, which noted that it's impossible to have a universal declaration of human rights. because human rights can't be universal. This was the American Association of Anthropology. So I think looking a bit back into history and the travaux préparatoires, the discussions that were had there, would see that it was really a coming together of ideas, be it as it may. So in my view, it's not a secularist, not a Western document. However, it is perceived as such, and that's what's important. So to make it relevant in context, it should be perceived as belonging to the local culture. And that's where the work that has been done in the past decades has been, and I think it's fantastic, and that's what we should encourage. And Reut, I couldn't agree more with you. I wasn't actually referring to Yael as French. I was referring to my specific interest in social constructivism and international law, which I still consider a bit fringe, although it breaks into mainstream these days. But yeah, which to my great pleasure, actually. Yeah. So on the topic of the armed groups, thank you, Patricia. Yes, so what we did in 4 of the countries, Colombia, Mali, Myanmar, and Libya, is to map all the active armed conflicts in those countries. So per country, we had at least 6 active armed conflicts. Most of them were non-international armed conflicts, so involving either the state armed forces and a non-state armed group, or several, or 2 non-state armed group. And yes, they qualified as parties to the armed conflict, and IHL was applicable alongside international human rights law where relevant. So you have, based on domestic legislation, for instance, in Colombia, you have armed groups that are recognized as such by the government, and armed groups that are not, that are considered illegal armed groups, but that doesn't make that for domestic legislation purposes, and also who can negotiate with them. For instance, the Catholic Church is allowed to negotiate even with the illegal armed groups under the domestic law, whereas others are not. But from the point of view of IHL, that's irrelevant. IHL applies as long as the threshold criteria are met, irrespective of what the government says. And we had that in the past. You know, we had it in Chechnya, for instance, with the Russian Federation arguing that there is no armed conflict, yet IHL was applicable. But yeah, one of the problems inherent in IHL.
We have a last question here, which I think was pretty much aimed on Ioana, but we could, I can ask you guys to close up, and then I think perhaps by 6:15-ish, we're gonna end. Then like, if you guys could look at the last question and then final remarks.
Oh, should I answer the question? To what extent is the new approach switch from religions to religious actors applied today in accordance with international law?
Yes,
how important do you think is it to clarify the rights obligations of actors to demonstrate that the beneficiaries of legal protection are religious actors and not religions per se? This is a really, really good question, or thank you for asking it. That's what I tried to do in my book, Religious Actors and International Law. So that was the approach that I took. I took a doctrinal legal approach, and I looked at state religious actors, international organization religious actors, intergovernmental, meaning the Organization of Islamic Cooperation, and a non-state religious actors, specifically under the European Convention of Human Rights. And what I showed is that although they claim a special legitimacy, this does not translate in a special legality regime under international law. They enjoy the same rights and they have the same obligations as their non-religious peers. From there, I moved into a very different type of research, socio-legal research that looks into their legitimacy and what they can do with that legitimacy, because I think doctrinal research simply does not answer the needs that we have on the ground nowadays in armed conflict, but also beyond. But it's a really good question.
I just wanted to say that I accidentally answered. So I just sent my article on Jerusalem because Peter, thanks for the question. Yeah, so Peter, it says it all. So I'm with you on all of it, right? So it's both the Ottoman legacy, but it's obviously also the treaty. So it's everything that's happened in Europe and everything that kind of determined what East did, East Europe as well. And the first Crimean War, right? And so it's all there. I mean, I can only just kind of advertise my own article on this issue and ask you to read it and let me know what you thought of it. And I wish I could see you too. So
everyone's allowed to advertise articles for people to read here.
Yeah. Yeah.
Professor Stefan, do you want to say your final words?
Yeah, no. I think I'll shut up in order not to prolong that whole issue. Thanks a lot for the interesting discussion.
Yeah, thank you so much. So wait, we're summing up. We're finishing. Is that like final words? Okay, cool. No, thank you so much. This was great. I'm so sorry that that it was a bit of a mess with the International Women's Day, but hey, we only get one day. You guys get everything. So,
thank you very much, Reut. We couldn't hear your children at all. So
okay.
Tell me about this. Seriously,
I literally begged them to just move to their room right now, which they did. So, but
they were super kind, and even if they wouldn't have been,
I agree. No, I mean, I just try to like be able to think, right? It's not that I'm apologizing for their existence. I just try to think while they exist, which is never really like a thing that.
Right. Yeah, thank you so much to all the speakers. Thank you, Marcus, for chairing the event. The event has been recorded, and I will stop the recording now. It will be uploaded to our YouTube channel and more events will be organized by our group. Thank you so much for your discussions. Really, really appreciate it. And certainly it has injected a little bit of more renewed direction to my research as well regarding international law, as well as teaching it, which makes it always very, very important and very interesting. Thank you so much. And I look forward to reading your article, Reut, as well. Very interesting. Thank you. And your research as well, Ioana. I think I will. I've taken note of your website. I will certainly look it up. Thank you so much. Okay, thank you.
Thank you. It was very nice meeting some of you and seeing new faces. Bye bye. And all faces. Bye bye.
Thank you. Bye bye. Bye.